Can everyone see the screen? Is it being shared? Yes, perfect. Thank you. So we'll just start. So I'm also just managing the people that are joining. So I'd just like to start by acknowledging the Larrakia people as the traditional custodians of the land that we meet on today, and I pay my respects to their elders, past, present, and emerging. I'd also like to extend a warm welcome to all First Nations people joining us today. Just a quick about us. I think most people here are probably familiar with what we do. So we're a community legal centre. We provide free legal advice and assistance. We have 3 services. So we have the general legal service that really, it's easier to say what we don't assist with. And generally that's criminal and family law, but most civil law matters we can provide advice or assistance. We have a tenants advice service that advises and assists tenants in matters under the Residential Tenancies Act. And we also have a seniors and disability rights service. They consist of a number of advocates that help people with all sorts of matters, including disability support pension applications and dealing with the National Disability Insurance Scheme. So today the CLE will be covering consumer complaints. I've tried to make it quite, I guess, easy to digest. So it's not really going to be that heavy on the law, but we will be going through a case study which shows the application process with the relevant provisions. There's going to be more of a focus on consumer guarantees because that's the main area that we see clients about, and it is usually the most common sort of issues with consumer complaints. So what we'll be covering is why have consumer protection? So what's the rationale behind it? Secondly, we'll be going through consumer protections and how it's regulated in the Australian legal system. And then we'll be going into depth on the consumer guarantee regime and basically how you enforce your rights under the Australian consumer law. So we'll just start with just an overview over the concept of consumerism. I'm sorry, I'm just admitting people in whilst presenting. So basically, consumerism is a concept which really, there are differing views on what it is, or it really has multiple meanings. One look of it is it's more focused on empowerment. So it's about educating consumers and giving consumers rights. Because ultimately the rationale is that if we build trust in our economic system, consumers will feel confident going out and buying. That will stimulate the economy and grow gross domestic product over that year, and basically, essentially grow the pie so there's more wealth in society. But there's also a critical view of it as well, a negative view, and essentially that's what those 2 pictures illustrate, is unrestrained consumption and economic growth just for the basis or for the point of growth. Is it worth it when we consider the externalities that it can create, which is things like increased waste, pollution, it can result in growing socioeconomic inequality as well. So there are really 2 views on consumerism, or 2 ways of interpreting it or looking at it. And generally, public policy will aim to strike an equitable balance between the quest for economic growth, but also bearing in mind that we do need to sustainably use our resources. So in Australia, there's been a progressive shift towards consumerism. So originally, the common law view has always been caveat emptor. So it's essentially let the buyer beware. So if the presumption is that 2 people, when you go and buy something, you're entering into a contract with the seller. And the responsibility is on you as the buyer to make sure that what you're buying is basically what you want, what you're seeking from the transaction. Essentially there are presumptions then that the parties are on equal standing. There's no information asymmetries between the parties, so there's full knowledge. And if the transaction doesn't work out, it's just on you. You've contracted to enter that transaction, and that's the end of it. Now, states and territories have always had a power to make consumer protections, which is a legislative intervention into the traditional common law view. So essentially, there was general power under the Constitution. So that would basically allow states and territories to make laws where they believe legislative intervention is required into that traditional notion of caveat emptor. So consumer protections have really developed based on, I guess, an understanding that the presumptions that have always been held are not exactly an accurate reflection of reality. Generally, especially when looking at the relationship between a consumer and a supplier, there is an information asymmetry there. The supplier is usually a subject matter expert. They have a lot of knowledge over the goods that they sell or the services they provide. And the consumer is most likely coming from a position of a layperson with no knowledge of that. And ultimately, it leaves them in a position where they could potentially be ripped off or cheated. So consumer protections is a legislative intervention to make sure that there is at least some form of recourse for a consumer if a situation like that were to arise. Now, originally, consumer protections were provided under state and territory legislation. So in the NT, we have the Consumer Affairs and Fair Trading Act. So that was originally where consumer protections were in the Northern Territory legal system. There are also general protections or legislative protections that were provided in other legislation. So the Sale of Goods Act in the Northern Territory provided protections to people who entered into a contract to buy things by description. So an example of that is you order something based on a specific description that's provided by the supplier, and then it gets delivered to you, or you go and pick it up and it doesn't match that description. So there were protections before the consumer law to protect a consumer in that situation. And it's still a protection that they have now under either the consumer law or under the Sale of Goods Act. Now, I'm just going to quickly move the screens. There we go, so I can wait a second there. So in the second reading speech, when the Australian consumer law was introduced, the then minister that was responsible for competition policy and consumer affairs noted that there were 17 national, state and territory generic consumer laws, along with provisions scattered amongst other laws. Now, the Australian consumer law is really to try and standardise it to fix that situation, so it could all be encompassed in a single piece of legislation. Now, the way this had to be done was the states and territories and the federal government basically had to enter an agreement to make a national law. Now, the federal government obviously has some specific powers that can cover these situations, and that would be under the Constitution regarding their right to regulate corporations, as well as, interstate trade, so the trade and commerce power. But essentially, they also needed the states and territories to also implement any consumer protections that they made at the federal level. Now, as I alluded to before, the objective of having a national system is to improve consumer well-being by providing protections. Now, ultimately, the intention of having those protections is to promote trust. Because if the economy operated with buyers and sellers not trusting each other, people would enter into transactions and it would just stifle trade and commerce. So it would have an impact on the broader economy. And as we can see with other countries, it doesn't tend to end well when that situation occurs. So I'm just making sure I didn't skip a slide. No, all good. So we've just got a case study. So meet David. David is looking for employment and is currently receiving a job seeker payment. David resides in transitional accommodation, which is not located near any public transport or prospective employer. David needs a motor vehicle because the lack of transport has created a barrier to finding employment. With the assistance of a caseworker, David is approved for a car loan of up to $5,000 under a no interest loan scheme. So this is sort of a recurring issue that we can see with the no interest loan scheme. It's a good thing to have this broader policy to help people obtain a motor vehicle. But what could be an issue there with the scheme when you look at it and the purpose that it's supposed to serve? Does anyone have any thoughts on that? No, that's fine. So generally, what sort of the quality of a vehicle that you can get for 5,000? It's not necessarily. It's very risky. You're basically going to be reduced to picking between used vehicles, and they're probably going to have quite a lot of kilometers on the odometer. So it means that this loan's been provided, but the loan is really putting you at risk of getting a vehicle that may not actually be fit for that purpose of consistent or reliable transport. That it's a very good point, Diana, about you need the money to pay the loan. Now, normally the good thing about the no interest loan scheme is that the repayments can be made through deductions in your Centrelink payment. Now, again, I agree that it wouldn't be ideal if someone's on job seeker, so you're getting a bit over $50 a day. So a deduction will have a big impact. So you want to hope that the vehicle is going to serve that purpose of hopefully overcoming a barrier to finding employment. But generally, especially in remote or regional areas or even in Darwin, it's going to be very hard to find a reliable vehicle for 5,000. So I'm sort of just giving an ominous inference about what's going to happen in this case study. Okay, it's not changing slide. Okay, so part 2, so we're just going to go into the Australian consumer law. So the Australian consumer law came into force on the 1st of January 2011. Now, the Australian consumer law, just bear in mind that it can be difficult for some people to find it. Now, the reason for that is it's not really an act. It's not an act in its own right. Basically, what's happened is that there's an act called the Competition and Consumer Act. The Act regulates both consumer law, but also competition policy in Australia. So within the Australian Consumer Law is contained within Schedule 2 of the Competition and Consumer Act. So if you go there, it will then suddenly have the Australian Consumer Law in whole. It reads like its own separate statute, but it's just a schedule in an existing, in a new one. As I said before, the federal government is obviously relying on corporations' head of power and the trade and commerce head of power in the Constitution. And then what happened afterwards was the federal government makes the Australian Consumer Law as the schedule of the Competition and Consumer Act. And then the states and territories each pass their own acts or amendments to their existing legislation basically they're called application statutes. So in the Northern Territory, for example, the ACL becomes the law of the NT through Section 27 of the Consumer Affairs and Fair Trading Act, which basically just states the Australian Consumer Law text, as in force from time to time, applies as the law of this jurisdiction, that being the Northern Territory, and as so applying may be referred to as the Australian Consumer Law NT. So the Australian Consumer Law provides a definition of what is a consumer. I've just simplified it because technically businesses can fall within the definition of a consumer. There could even be arguments that government departments could. But essentially the easiest way of looking at it is this exclusive definition. So essentially it's the amount payable, for the goods or services. Was it $100,000 or less? Or were the goods or services of kind ordinarily acquired for personal, domestic, or household use or consumption? There are some other criteria that can also be applied, but those are the two most applicable when dealing with an individual consumer. It used to be 40,000 as the limit, but there's regulations, treasury regulations that update that and change it. And last I was aware, it was 100,000. The other thing is that there is a presumption that a person is a consumer. So basically, if someone's alleged that they're a consumer, the presumption is that they are until the contrary is established. So that would most likely be the other party trying to argue otherwise. Now, the other important thing with a lot of consumer protections, but not all, is that some protections only apply to the supply of goods or services in trade or commerce. So generally that means it needs to be in Australia or have some connection to Australia. The other thing is that in trade or commerce has competing interpretations, as most things do in the legal system. Some people advocate for a narrow interpretation or a strict one. Others ask for or promote a broad interpretation. Now, generally, courts, as they did in concrete constructions in Nelson, generally they side with the narrow interpretation. So usually, they're normally looking at stuff that's directly related to the running of a business, so operating for profit, in dealing with a consumer. So as they say here, the central conception of trade and commerce, and not the immense field of activities in which corporations may engage in the course of, or for the purposes of carrying on some overall trading or commercial business. Now, the example that they gave that they used to sort of explain why a broad interpretation shouldn't be favoured is that theoretically, if a broad, expansive interpretation of in trade or commerce could apply, they said basically someone indicating the wrong way in a company truck, like an employee driving a company truck, indicating the wrong way on a road, that could technically fall under the definition of misleading and deceptive conduct if trade or commerce was defined quite broadly. So normally what we're looking at is transactions with consumers. So going to JB Hi-Fi to buy a television, that's clearly a trade or commerce. So the Australian consumer law separates things into general protections and specific protections. Now, as Alex Bruce, who's a leading expert in consumer law, identifies, the easiest way to explain it is the general protections is normally looking at the circumstances surrounding the conduct. So there are infinite situations or infinite ways to engage in things like misleading and deceptive conduct or unconscionable conduct or unfair contract terms. So what you're normally looking at is the circumstances in which it happened. So was it in circumstances where a class of people were likely to be misled or deceived? Was it in a situation where a supplier was aware of some disadvantage on the part of the consumer and then took advantage of that disadvantage? Or is it a situation where it is unreasonable or unfair for a supplier to rely on a term in a contract? Is it excessive in protecting their rights? Now, the specific protections, that's normally not looking at the circumstances, it's looking at specific practices that are well known. So practices, scams, and forms of behaviour that are detrimental to consumers. So what they're looking at is specific types of practices, like there's a prohibition on bait advertising. So putting out an advertisement for something that you know you can't supply and that you don't have. in hopes that it attracts a consumer, so you can try and flog something else out, or flog something off to them, something completely different. A prohibition on wrongly accepting payment. So have you accepted payment knowing that you cannot actually deliver the services or the goods to the consumer? Or you have reason to believe that you cannot deliver the goods or services to the consumer. Prohibitions on unsolicited supplies or services. So that can be stuff like sending stuff to someone via post and then sending them a bill, even though they didn't ask for it. Or a good example could be with services, a mechanic. Maybe you take your car in for a service. The mechanic does additional work beyond what was agreed and then tries to bill you afterwards. The other thing is prohibitions on pyramid schemes. So that's essentially scheme that makes revenue through recruiting people rather than selling a product or services. And then there's other protections like the provision of consumer guarantees, regulations on lay-by agreements, regulations of gift cards. So a good one there is that there's now a rule that gift cards can't have an expiration date that's sooner than 3 years from the date of supply. And rules about product safety also fall under a specific protection. So we just go back to the case study. So David and the caseworker at his transitional accommodation, they attend a local dealership to browse used cars. The salesperson shows David all the used vehicles they believe would meet David's needs. David selected a vehicle from the short list of stuff of vehicles that the salesperson showed them. When showing the vehicle to David, the salesperson draws David's attention to damaged paint on the doors, a damaged front bumper, and cracking on the rear windscreen. The vehicle was manufactured 7 years ago, and the odometer is approximately 100,000 kilometers. So it hasn't been used too much. Due to the damage, the salesperson offers to sell the vehicle for $5,000. The salesperson also verbally states that the only damage to the vehicle is superficial, so it's just the stuff you can see. So the paint on the doors that's damaged, the front bumper that's smashed, I guess, and the cracking on the rear windscreen. David is happy with the vehicle and he enters into the contract of sale with the dealership for $5,000. The contract of sale states nil under heading known defects. And David is repaying the nils loan via deductions in his job seeker payment. So we'll move on and we'll get back to David soon. Where we'll be in a situation where we can start unpacking what's happened. So we'll go on to the consumer guarantees. So these are just people are maybe aware of the concept of a warranty. So that's when a supplier basically is attesting to the quality of something, of their goods or their service, by saying, hey, you can purchase this from me, and if there's any issues within, say, 2 years from the date of purchase, I'll replace it myself, or I'll cover the repairs. So that's called a warranty. That's something that's an express warranty that's provided by the supplier. Now, the consumer guarantees, I guess, recognise that not all suppliers provide warranties or provide that sort of confidence in what they're supplying. So essentially, there's now a statutory regime which provides consumers with a thing called guarantees. So it's a set of basic obligations imposed on the supply of goods or services to a consumer, and it basically provides warranties to goods and services that may not otherwise have been there if these provisions weren't enforced. Now, something that people do need to know is that most consumer guarantees, but not all, do not apply to private sales. So where one person is selling to another, so for example, when someone's selling a house to another person, or a private motor vehicle sale, so say you see a car advertised in Gumtree, you go and meet the person, you agree, you buy it, you're not going to be covered by things like the guarantee as to acceptable quality. So there's not going to be any recourse if there's then an issue with the vehicle. Essentially, in that situation, it's most likely that the common law view of caveat emptor, like the buyer beware, will apply. So it's more, you should have done your due diligence by getting an independent mechanic to inspect it before purchasing it, that sort of thing. Now, the other thing is most consumer guarantees also do not apply to the sale of goods by auction. Again, some do. Now, consumer guarantees cannot be excluded by contract. So if a supplier does try and exclude it, that would contravene the Australian consumer law and would be invalid or most likely be invalid. And some products and services are not covered by the consumer guarantees, so it's not universal. So things like insurance aren't covered. There's a consumer guarantee as to services, that services will be fit for the particular purpose of which they're obtained. And that guarantee doesn't apply to professional services by a qualified architect or engineer. For some reason, they've expressly excluded them from that guarantee. So these are the guarantees related to the supply of goods. So we have the guarantees to title. So I believe that one does apply to private sales. And really what you're looking at there is, does the person who's selling it actually have the right to sell it to you? Are they the actual owner? So there's generally a guarantee that they are, and if not, you could seek a remedy against them. There's a guarantee as to undisturbed possession. So an example of that could be that you purchase a car and then it gets repossessed shortly after, and no one's told you that there was, I guess, undisclosed, and as we'll go on to the next one, undisclosed securities on it. Or maybe you buy something and then find out that someone else is also using it too. Which it'd be awkward when you find out. There's also the guarantee as to undisclosed securities. So generally, if something's covered by the Australian consumer law or the consumer guarantee, they're basically, there's a guarantee that there should be no, I guess, secured loan against the thing that you're purchasing, unless they've told you otherwise. The main one that we see, and I assume it is the most common, would be the guarantee as to acceptable quality. So that's just where something is just purchased it and it's unsafe, it's not durable, it's not fit for this purpose which is obtained, that sort of thing. There's a guarantee as to fitness for any disclosed purpose. So that's if you informed the supplier of the specific purpose that you're using the good for, or they should have reasonably known by implication. There is a guarantee that it needs to be fit for that specific purpose. If not, there's obviously a process to seek recourse. And then again, things like supplying goods by description or sample or demonstration model. So for example, if there's a supply by description, it will match that description, or if it's supply by looking at, say you order a car and you look at another car that's supposed to be the sample or demonstration model, there's a guarantee that when you receive the car that you've ordered, it should match that sample or demonstration model that you were shown. There's a guarantee as to repairs and spare parts. That's normally binding on manufacturers that their products will basically have spare parts available and people that can repair it in the event that something went wrong. And there's also a guarantee as to express warranties. So that's usually trying to keep suppliers to their word. So if they have an express warranty to repair something after 5 years, it breaks down after 5 years, oh, not after 5 years, but after 4 years, you go back to them, they try and get out of it. The guarantee is that you can hold them or try to hold them to that express warranty that they've provided. Now with the guarantees as to goods, it sort of operates the same way as a warranty does, in that it uses what in marketing they refer to as the bathtub curve. Basically, I'll just draw it. Just looking at a bathtub. Y-axis is likelihood of failure or an issue with the product. X-axis is time elapsed. So likelihood of failure on this side, Y-axis, X-axis, amount of time that's elapsed. Generally, when you buy a product, it is most likely to break down either within the initial stages of that product's life cycle or at the end stages of that product's life cycle. If something gets past that initial stage, it's very unlikely that it's going to break down until it gets to the end of its life cycle. So the warranties and guarantees, essentially they're there to cover you during that initial period. That's the point. That's why it's not lifetime normally, because everything breaks over time, like everything. All products have a life cycle, and that's just how it is. Warranties and guarantees are to protect you in the event that there is an issue with the product, and that's when you'd be having an issue on the left side of the x-axis. Now we go on to the guarantees relating to the supply of services. There are three guarantees. One is the guarantee as to due care and skill. So basically, if you engage someone to do work for you, say it's to repair your motor vehicle or to do some repairs around your house, there is a consumer guarantee that if that's in trade or commerce, that they will exercise due care and skill. So they'll perform to the standard that's reasonably expected of a person in that sort of trade, I guess, or occupation. There's also guarantees as to fitness for a particular purpose. This is really similar to the fitness for any disclosed purpose in the supply of goods. Now, the thing with the services is basically it's a guarantee that they're services or a good that results from the services, because sometimes you're engaging someone to perform a service, sometimes you're engaging someone to perform a service that will result in a specific product or good. So it's basically a guarantee that the services will address that particular purpose, or the good resulting from the services will address that specific purpose. And then there's finally a guarantee as to reasonable time for supply. So that's normally used when a contract is silent as to when the services are to be performed and completed. So if there is nothing in the contract about the time or the completion date, the consumer guarantees provides a protection that they need to at least provide those services and complete them within a reasonable time. Now, obviously, with a lot of these things, it's going to be bearing on the facts of the case, because what's reasonable, people will have competing evidence first about, for example, what's a reasonable time for supply of certain services, and it may differ depending on what services they are specifically. So if we just go back to David's car troubles, now he's got the vehicle last we spoke, or last we saw David. Now a few weeks have passed and he's been driving the vehicle and he's been noticing some issues. So the first one is that the vehicle's leaking oil. The second is that it's difficult to control in the rain. And the final issue is that it vibrates and makes squeaking noises when stopping, which is very concerning. Now, to make matters worse, as we remember, David's in transitional accommodation and the oil leak has now created a mess on the driveway. Now, he's had a guest visit and the guest has walked through the oil leak. They weren't aware of it, and they've now tracked the oil into David's unit. And the operators of the transitional accommodation, obviously they're sympathetic to David's circumstances, but they are insisting that David needs to clean both the driveway and the unit, and he's probably going to have to pay to either get the suppliers to do that cleaning or pay someone to do the cleaning. So there's now the oil leaks now led to other impacts on David's life. Now, David and the caseworker decide to take the vehicle to an independent mechanic, and the mechanic identifies a number of issues. Now, the first one, sorry, I'm just admitting someone in. The first one is that the oil leak is being caused by a cracked oil pan. And if the cracked oil pan is not replaced, the risk is that the vehicle might experience catastrophic engine failure. So obviously, when you see a mechanic, a lot of the time, the work that they'll do is preventative. And the point of it is that you can do a task that costs $1,000 now, or you can wait. And it may mean that if you wait, you could have a repair job that's costing you $10,000 in the future. So what they're basically saying to David is, look, you can fix the oil pan now, or you can wait and potentially be paying 10 times as much to get a new engine. Second issue is that the tyres are worn, which may lead to tyre failure if not replaced. So there's a huge safety risk there, because if this tyres pop whilst driving, it's probably going to lead to a motor vehicle accident, and potentially physical injury. And finally, the brake pads are faulty, which may lead to brake failure if not replaced. So again, it's a safety issue, because if the brakes don't work, obviously we know what's going to happen. The mechanic estimates replacements to be approximately $2,500, and if not replaced, the replacement costs for the new engine and the new braking system will likely exceed $8,000. So it's that stitching time concept. You can pay that 2.5 grand, which is half the value of the vehicle, I might add, to repair it and make it roadworthy again and safe and working. Or he could drive at his own risk in this vehicle. And I mean, best case scenario, he pays about 8 to 12 grand to replace the engine and braking system when they fail. Worst case scenario, he could die. So the mechanic also believes that the vehicle will not pass the next scheduled roadworthy if the defects are not replaced. So he is in a position where if he wants to avoid breaking the law, he really needs to get it repaired or stop using the vehicle. So sorry, just before we skip ahead, does anyone want to guess what consumer guarantee could apply in this situation? Fit for purpose, yeah, that's something. But is it a specific purpose, or is it a subset of another guarantee? That's something we'll explore, yeah. Expect. Anyone else? Due diligence not given originally. Fit for purpose, yeah. With the Diana, just to clarify, with the due diligence, is it more the fact that is it about the dealer's, the salesperson's conduct, or is it the responsibility on David to have got the mechanic to check it before purchasing it? Salesperson has experience, yeah, correct. So you could say that it would be reasonable to rely on that, on the salesperson's expertise. And I believe in the facts. I did simplify it, but originally in the facts, and a very good point, is that I did have the salesperson state that they did have a lot of expertise about this matter. But I was worried that we'd go into a situation where we'd be exploring like 10 different guarantees. So I thought it would be easier just to simplify it. The main one that we're going to focus on, so fit for purpose is a very good one because it technically is one of the considerations that we will be looking at. Now I've just simplified it, and the reason for that is I think there could be a very good argument about fitness for any disclosed purpose. Because if we look at the facts, go back to the case study, the sales person showed David all the used vehicles they believe would meet David's needs. And then if we go back again to ascertain David's needs, David needs a motor vehicle because the lack of transport has created a barrier to finding employment. So he needs it to find work, and the vehicle needs to be able to drive. Now, the good thing here is I don't think David even needs to go as far as arguing a particular purpose or a disclosed purpose. Because what is the purpose of a motor vehicle? Just in general, what is the purpose that it serves?
A vehicular propulsion.
Yeah, yeah, transportation. So if it doesn't do that, it doesn't fit just the basic thing that it's a vehicle is acquired for. So generally, with disclosed purpose, it creates an additional barrier because you normally need to show that either you let the person know that you made them aware of that particular purpose. And as we know, with all disputes, there's going to be two sides to the story. One is obviously going to say, I let you know. And the other side, there's a very good chance they're probably going to say, I don't recall that. Or if they're very confident in what they've said and they in fact never did let that, they were never made aware, they'll just blatantly say that they weren't made aware of it. So it makes it a bit tougher because you got to prove that additional standard when really the nature of a motor vehicle is transportation. So it is just the basic requirement. So the one that I'm really going to focus on, is acceptable quality. So that's section 54 of the Australian Consumer Law. It's the most common one that we see with goods. So essentially it states that if a person supplies in trade or commerce goods to a consumer and the supply does not occur by way of auction or way of sale by auction, there is a guarantee that the goods are of acceptable quality. So if we just break that down, is it in trade or commerce? He's gone to a motor vehicle dealership. Yeah, so yes. And is David a consumer? Are the goods, well, firstly, we know they're $5,000. It's under that $100,000 threshold. We could even add the second criteria of that they're usually, a motor vehicle is usually acquired for domestic and household or personal use. And we know that it wasn't done by auction. So the guarantee, we can conclude that there's a strong argument that it applies. Now, if we look at goods are of acceptable quality, if they are, so A, fit for all purposes for which goods of that kind are commonly supplied. So can the vehicle be used? What is the primary use of a vehicle? As you've already said, it's transportation. Can it be used for that purpose? I think we can easily conclude that there's a strong argument that for a no. It needs to be acceptable in appearance and finish. So we will go and look at the other side of the story as well. But just looking at it from David's perspective, what about the second criteria, acceptable in appearance and finish? So what were the issues of the vehicle? And don't worry about it, there's no wrong answer because it's just going through something and working through it together. Oh, I've gone back too far. Here we go. So what were some issues with the appearance of the vehicle?
Well, there were the superficial ones that were pointed out to him, but he accepted nonetheless.
Yeah, so we're going to go into that. Right now we're just looking at David. But yeah, there was superficial defects. The vehicle, the cracked rear windscreen, the scraped paint on the door, and the smashed bumper. It needs to be free from defects. So we've got lots of defects. We've got the superficial defects, but we've also got the ones that we just covered. Cracked oil pan, tires are worn, brake pads are faulty. Is it safe? Well, we know what the likely answer is. Yeah, who's to say? Obviously, the other side could argue that they may be of the view that it is safe. It would ultimately be for a court or tribunal to make that decision, but we look at it from the perspective of prospects if an argument was to be made. And I'd say there are probably strong prospects to argue that it's not safe. So not with acceptable quality on that ground. For a reasonable person without mechanical experience, the superficial defects were acceptable. Yeah, correct. So there could be an argument from there, from David's view. And it needs to be durable. So just based on that, sorry, the IT problems again. There we go. So it needs to be durable. Well, it looks like it's not going to be lasting very long at this rate unless those repairs are made. So there's probably a strong argument there that by David that it's not durable. And again, it's being argued from an objective standard. It's not based on David's subjective beliefs. It's not based on the salesperson's subjective beliefs, but instead, when looking at those matters and determining if something's of acceptable quality, it's from the perspective of, so it's an objective test from the perspective of the reasonable consumer fully acquainted with the state and condition of the goods, including any hidden defects, would regard as acceptable. So you're looking at it from the perspective of a reasonable consumer, and then you might say, who is a reasonable consumer? What is their mindset? Well, there's some matters listed out that let us see. It gives us some insight into the thought processes of that reasonable consumer, and it's in subsection 3. So the matters for the purposes of the reasonable consumer and considering these criteria for acceptable quality is the nature of the goods. Now, this is when we're really going to be looking at it from both sides. So the nature of the goods, so it's a second-hand, well, it's a used vehicle with 100,000 kilometers on the odometer, and there's some issues with the vehicle, albeit superficial. The price of the goods is relevant, so they would consider whether this is something that's reasonable to expect from a vehicle that's sold for $5,000. Any statements made about the goods on any packaging or label of the goods. Any representation made about the goods by the supplier or manufacturer of the goods. So that's the superficial defects. It's better to address that later though. And the fact that on the contract they said nil defects, when under known defects, that could possibly mean that there was no way of knowing about the other stuff that came to light later. And any other relevant circumstances. So these are just things that the objective reasonable consumer would be considering in determining whether the goods are of acceptable quality. It would likely be the standard that the court or tribunal really needs to, or the criteria that they need to look at, or considerations they need to look at in determining whether the criteria of acceptable quality was met. Now, if goods are supplied to a consumer, if goods supplied to a consumer are not of acceptable quality, and the only reason or reasons why they are not of acceptable quality was specifically drawn to the consumer's attention before the consumer agreed to the supply, the goods are taken to be of acceptable quality. Now, who is likely going to raise that subsection, and what would they likely raise it in relation to?
So that nil known defects. Checkbox that's
yeah, but there's an added layer of complication because I don't think the contract alone is going to have a big difference when we look at the facts for certain defects. Now I'm just going to answer it because Diana's technically already answered it, albeit indirectly. Now the superficial defects, if we go back. Oh, sorry, let me just get through the IT glitches. If we look at the facts, it states when showing the vehicle to David, the salesperson drew David's attention to damaged paint on the doors, a damaged front bumper, and cracking on the windscreen. So there's probably a very strong argument by the supplier that those superficial defects do not make the vehicle not of acceptable quality. Because they before David acquired the vehicle, they pointed it out and they clearly showed it to David, and David was still happy to purchase it. So that's probably, those are probably defects that won't be actionable. Now there are one more criteria. Here we go. I'm just working out which one is the one that applies. So it's paragraph 7 may also be something that the supplier could rely on. Goods do not fail to be of acceptable quality. If the consumer acquiring the goods examines them before the consumer agrees to the supply of the goods, and the examination ought reasonably to have revealed that the goods were not of acceptable quality. Now, there are obviously two arguments that could be made there. The first one is David could argue that there wasn't really an examination of the vehicle, because there was no, for example, he hasn't engaged a mechanic to go and do it or something like that, so he couldn't uncover the specific defect. Now, another argument could be by the supplier, and that's in relation to one of the major defects. Does anyone want to take a guess which one that is? Could David have been doing it? Burnouts and dry? Yeah, so that's a good
David,
yeah, so that is a good point as well, Ronnie. So if you've caused the defects, it doesn't, it means that can't be considered, I guess, a failure to provide something of acceptable quality if the consumers in fact caused the damage. So if it is found that David did cause the damage, it's likely that there is no breach of the consumer law. Other than, oh Lord, I guess tires being worn out. Yeah, correct, Josie. So the tires being worn out and the oil leak, there could be an argument by the supplier. And again, I'm not saying any of these arguments would succeed, but there could be a very good argument by the supplier that David could have observed that when looking at the vehicle and noticed that that there were defects in place, especially the tires, because you can generally see when tires are worn. So there could be an argument that David should have been able to see that just when he looked at the vehicle and noticed that there were those defects. So we move on to the last bit. Now, I'm not gonna provide it's a cliffhanger, this case study. So this is where we leave David. The reason for that is I feel like it's, in my experience of a lot of consumer law matters, it's not usually a happy ending. So I don't want to sort of create false hopes. The thing with consumer law, so I'm just going on a bit of a rant. So it's great that we have these laws that provide strong protections to consumers and gives consumers rights. That's a very good thing, but again, with rights, the issue is always in enforcing them. And the thing is, it's never that easy. The way it's promoted in some channels is that it's as simple as going back to the supplier and simply saying, hey, you've given me a lemon, take it back, I want a refund or repair it. And then that's the end of the story. That's not how it works in reality. It's most likely that it's going to be disputed, and the person will likely have to then pursue legal action to take it further. And the thing about something like a motor vehicle is it's very technical. It's not something that a layperson can easily advocate for themselves. They're probably going to need some sort of independent mechanics report. This relates to most consumer law matters. You're essentially bringing an argument against someone who's most likely a subject matter expert and trying to argue on the balance of probabilities that they're wrong and that they've given you the dud. So it's not easy. That's the thing. It's great that these protections are in place, but when it comes to enforcing them, there's a lot of difficulty and a lot left to be decided. At the same time, there is a process for a reason, and both parties do have a right to be heard, because there are obviously also instances where there may not be any issue, and it may be the consumer who's either caused the issues or is making it up, or maybe it's just not having regrets about what they've purchased. So we have the process for good reason. And I would say it is striking a balance between certainty for suppliers and the rights of consumers to protections. But it would be good if there were some other alternative dispute mechanisms. And we will go through those, and the ones we have now are good. But it would be good to see if there are going to be any future reforms in this space as well. And a good example of something that could be beneficial, going off a bit of a tangent here, things like unfair contract terms, for example, if we go back, where is it? Sorry, I need to, takes a while to respond. If we go back to the general protections, would the salesperson be liable? That's a very good point, Josie. And now you've reminded me that we aren't actually leaving David. We are going to go into that. But thank you for the prompt. Because we will be going into that. Now, with the specific general protections of unfair contract terms, for example, in the past, if it was found that a term in a contract, a standard form contract that's given to a consumer on a take it or leave it basis, and the consumer's entered into it, and then it's later found that by a court or tribunal that a term of the contract that or a specific term of that contract was unfair, what used to happen was it was simply just removed, it was severed from the rest of the contract. That's it. You go to court, there's probably a risk of costs, and all you're getting really at the end is if you're successful, you might sever a clause in a contract, so remove it. There's been a reform that I think is quite encouraging, which actually gives the power to fine suppliers that are found to have an unfair contract term in a standard form consumer contract. So protections like that always are encouraged. Obviously, you need to look at each of them on a case-by-case basis. But that's an example of areas where there could potentially be improvement. So we'll move on to the remedies relating to guarantees. I'm just going to move the chat box. So essentially, with consumer guarantees, the section you look at, if a consumer guarantee isn't complied with, is if it's a good, you want to be going straight to 259. That's basically outlines your remedies relating to a contravention of the consumer guarantees regarding the supply of services. Of goods. And if it's regarding services, you want to go to section 267, because that outlines your remedies relating to consumer guarantees through contravention of a guarantee relating to the supply of services. Now, your options ultimately depend upon whether the failure to comply with the guarantee can be remedied or is a major failure. Now, as always, with almost all legal matters or any sort of dispute, you always go to the other party first and try and resolve it directly. That's always, because chances are it's one of those 5% of cases where it's just fixed. If it's a major thing, and if it's a really small minor thing, big suppliers like Kmart, stuff like that, they'll normally remedy it pretty quickly. They've got reputational things that they need to consider, and they want to have that reputation of being a supplier of choice, I guess. So they make sure that they address consumer concerns quite promptly. There we go. So what is a major failure? So a major failure, it really depends on whether it's good or service. Some examples of major failures can cover both. But essentially it's looking at stuff such as whether the goods or services would not have been acquired by a reasonable consumer fully acquainted with the nature and extent of the failure. So in the case of David, do you think there's a strong argument that there's a major failure just on the first round? These are all exclusive, you just need to address one. Do you think a reasonable consumer that was aware of all the defects of the vehicle, would they still go ahead and purchase it for $5,000?
Probably not.
But yeah, that's a good point. So there's probably going to be a factual argument before applying all of this about when the defects actually occur. But in the event we assume that they were there when you purchased it, yeah. I think it's safe to argue that a reasonable consumer would not acquire the vehicle, because even then you're acquiring it for $5,000 and the repair cost alone is half of that. So it really changes the nature of it. Now the other things, I'll just go over it quickly because I'm noting that we are running out of time. You can look at stuff such as whether the goods or services are substantially unfit for the purpose for which goods or services of the same kind are commonly supplied, and they cannot easily and within a reasonable time be remedied. Other stuff could be if they're unsafe, if the goods are not of acceptable quality, so we just go back to the provision. So as we noted, acceptable quality meant that the goods are safe, here on subsection 2. So obviously if it is not of acceptable quality because it's unsafe, that's a major failure. Or supply of services create an unsafe situation, that's a major failure. Now, generally, the first thing you look at is, can it be remedied? That's normally the first thing I look at. And if it's a yes, if it is a yes and it can be remedied, then I look at the major failure considerations or criteria that don't relate to remedying the defect. So that's they could, that a reasonable consumer, would a reasonable consumer have acquired it, and is it unsafe? Now, if a failure to comply with consumer guarantee can be remedied and is not a major failure, so can be remedied and is not a major failure, a consumer may ask the supplier to remedy the failure within a reasonable time. Now, in David's case, I think there's a strong argument that on the one hand, it can be remedied, but on the other hand, there could be a strong argument that there is a major failure if the goods had the defects when he acquired them, just because they're not safe. If there's an issue with the brakes or with the engine collapses, obviously the vehicle won't be safe. And there's also that other argument that a reasonable consumer probably would have acquired a vehicle knowing the extent of the defects. But if those weren't considerations, it could be that it would just be a minor failure. Now, the only difference is that if it's not a major failure, you have to go to the supplier first and ask them to remedy. So that's the difference, is that David would have just an initial step of asking to fix it. And then when they say no, or if they say no, it just goes to the standard process that you would have with a major failure anyway. Now, when it comes to contacting the supplier, always best to do it in writing. Now, Consumer Affairs has really helpful templates, and I actually usually recommend that people go and see Consumer Affairs and get that template sorted before they actually see us. Now, I'm just going to quickly open the link and just so you know where it is. Make sure that I'm sharing the screen with the Consumer Affairs link. There we go. Here we go, got Consumer Affairs. Just to navigate it, I'll just go back, go to their homepage. Here it is. Consumer Affairs is the regulatory agency in the Northern Territory. They're sort of like RACCC, which is at federal level. You just go to For Consumers, Complaints and Disputes, give it a click, go down, and there's sample letters requesting remedies. So we've got the first one, sample letter requesting remedy for a faulty good, or sample letter requesting remedy for a service. Now we look at the good. So David's letter. Just make sure that I'm sharing the same page. Yeah, I am. And basically you're just filling in the blanks. So it's all set out for you. It's a very helpful tool. And yeah, if you've done it, you can even send it to us afterwards. We can have a look at it. There we go. Now, if the supplier refuses or fails to remedy the issue, or the failure is a major failure, the consumer can remedy it themselves and seek to recover all reasonable costs incurred or a refund, or in the case of goods, a replacement. So let me just break that down. So if it's a good, like a car, refund or replacement at roughly the same value. If it's a service, normally you go and get you could ask for the refund of all the amount that hasn't been expended to date or used by the supplier. Now, which option to choose really depends on the likelihood that the consumer thinks they're going to get stuff back and their personal needs, or their the demands on their life in general. Now, the reason for that is if you remedy it yourself, you're putting yourself out of pocket, and there's no guarantee that A, you succeed in pursuing legal action against the other party, and B, even if you do succeed against the other party, they may not be able to pay or they may not pay. So when people basically incur it all out of pocket and then want to seek it afterwards, we're usually very clear that you need to be well informed that you may not recover any of that money back. And usually it will be in the cases of stuff like motor vehicles where you don't really have a choice because it's a real disruption to your life if you don't get it repaired. Now, the delayed option is obviously to seek the refund or replacement and pursue them for legal action, in which case, if you're unsuccessful, you might get a cost order against you, but at least you're not out of pocket. But you probably have to, if you're unsuccessful, you need to spend the money anyway to repair it. Now, a consumer can also, and this was a good point that Josie brought up, a consumer may also recover damages for any loss or damage suffered if it was reasonably foreseeable that the consumer would suffer such loss or damage as a result of the failure. Now, how does this relate to David? Oh, it's already in the chat. The oil leak. So obviously, there's going to be costs in fixing it, cleaning that mess, both in the driveway and in the house. Now, do we think regarding the oil, if we separate the two issues, so we've got the driveway as one and we've got the unit as the other, do we think David has a strong argument for the driveway? Oh, not David, sorry. Yeah, David. Does David have a strong argument for the driveway? Is that a foreseeable consequence?
Yeah, I mean, it's a foreseeable consequence. You transfer your house, but also it's foreseeable.
No, we're not going on the house.
You don't walk into the oil.
Yeah, so I agree with Diana. I think David can make an argument about the driveway, that is like a reasonably foreseeable consequence of the contravention of the consumer guarantee of selling the vehicle with a cracked oil pan, that it may make a mess in the driveway, and that David would probably have to expend some money to fix that mess. Now, but what about the guest walking through the house? So trampling through the oil spill and then dragging it into David's unit. No, I would agree with you on that, Josie. I think it's a bit remote because you got to look at it from the other side's view. Is it reasonably foreseeable that if I sell you a vehicle with a cracked oil pan, oil's going to leak, and some random person is going to walk through the puddle of oil and track that oil into your living area? I think both sides could make arguments, but I think it might be a bit of a stretch with the second situation. We will be sharing the slides and the recording as well, just to answer the latest question on the chat. Now, let's just look at it from David's view. They've requested them to repair it. They've given them the benefit of the doubt. The other side said no. What does David do? What do you do after that? Now, there's a few things. You could go to Consumer Affairs. They do conciliations. Now, the thing is that both parties need to consent to that though. And if the other side's not going to agree, or you can't resolve it in conciliation, the issue is that you're going to have to pursue it through legal action. You could try the community justice centre. You got the same issue though. Parties have to consent to that. Both parties. There's no point doing a mediation with only one of the parties. It would just be that'd be the definition of a waste of time, or if it's unresolved. So it would you go for legal action. Where you would go, most likely, it depends on the amount that you're seeking. If it's 25 grand or less, you'd be going to the Northern Territory Civil and Administrative Tribunal. If it's up to 250 grand, local court. And if it exceeded 250 grand, you would need to go to the Supreme Court. That's a big consumer issue. In that case, you would need a hope that it's from the reasonably foreseeable consequence, the damage. Because if the good you purchased was over $100,000, you really need to show that it was for a domestic personal household use, because you're not getting in on the cap. But yeah, it essentially means you do have to, the next step would be legal action. Now, where you can go for help, the consumer law matter. There's a few places you can go. So there's us, obviously, Durham Community Legal Service. You can go to Consumer Affairs. They're very helpful. They can set up conciliations. They normally try and talk to both sides to try and work out some sort of solution. Because usually you want a solution that both parties can agree to, because you know that it's more likely they're going to stick to it. You don't want to, like, well, in the worst case scenario, imagine if you went to the Supreme Court, got a big order, and they just didn't pay, or they wound up their business and you got nothing. Like it's always best to try and get stuff resolved directly. Other places you go is the Northern Territory Legal Aid Commission, or the North Australian Aboriginal Justice Agency, so NAJA. So these are all good places for a first starting point. And I'd imagine, as with the other services, it would be similar to us. If we can't help, we can at least point you in the direction of someone who may be able to. So that's where to go. Other than that, thank you for all your time and your attendance. Are there any questions? Oh, yeah, very quick as well. Good point, Josie. So generally with things like costs, NTCAT, local court and Supreme Court, obviously they're courts, so there's a presumption that costs follow the event. So it's just to be expected that there would be a costs order, so that's always going to be a risk there. NTCAT's different, Northern Territory Civil and Administrative Tribunal. They, just for the benefit of the non-legal people in here, they have the small claims jurisdiction in the Northern Territory. So 25 grand or less, it's a small claim in Northern Territory Civil and Administrative Tribunal. Now, where it differs is that in the NTCAT, there's a presumption that parties bear their own costs of a proceeding, but that doesn't stop NTCAT from making a cost order. They can still make one. Usually there needs to be some special or exceptional circumstances that justify moving away from that presumption and making a cost order. So they can still make the cost order, but the risk of a cost order is substantially lower than a court where it is to just be expected that their costs follow.
Outside of the filing fee.
Yeah, outside the filing fee. Normally this filing fee is generally awarded to the victim. If they've claimed it, if the applicant's claimed it. Perfect. Thank you very. Thank you, Samantha. Any questions? Would David still have to pay his loan if he has no car fit? That very good question as well. Now the problem is that there are two transactions here. One is an agreement between David and the salesperson or the car dealership. In that case, what's happening is 5,000 is being transferred by David or on David's behalf to the dealership, and the dealership in return is providing a motor vehicle. There's also a separate transaction, which is that David will borrow $5,000 from the no interest loan provider, and he will pay it back in installments, most likely through deductions in his Centrelink payment. They're two separate things. So it means that technically, David needs to pay it back still. He will still be getting those deductions in his Centrelink. Theoretically, the NILS provider could say it's not our concern that you've bought a lemon. Now, that doesn't stop David from going to the NILS provider, letting them know what's happened and asking if they will consider a waiver on some sort of concessional ground or for some hardship. He can still do that, but that's a separate thing that David will need to bring up with the NILS provider. Because in the absence of doing that, the expectation will be that David has to pay it back, and most likely the legal argument is David has to pay it back. So David would need to maybe engage a financial counsellor, someone like Catholic Care, and see if they can talk to them on his behalf, or whether he just wants to try and advocate for himself. But it would need to be an arrangement that's sort of an ad hoc arrangement that's negotiated between David and the NILS provider. Yeah, he'd be completely separate from the consumer law matter. Thank you. Thank you, Josie. Low income people need more justice, don't they? Yeah, and that's something we observe. It seems that the less money you have, the more expensive things tend to get, and it is quite difficult. But there is a process, and there are services that can help in that situation. And I'd say financial counsellor is probably the first port of call in dealing with that situation. Perfect. So if there's no other questions, I'll just stop the recording and thank you all for your active participation and attendance today.